Hi, very good morning. This is a Bombay High Court judgment, income tax, transfer pricing judgment. Principal Commissioner of Income Tax versus Sterling Oil Resources Limited. So, this judgment ends with a quote, which I am giving it in the beginning. The quote is: ask the runner who loses the medal by fraction of seconds. 2. Ask the doctor who can't reach the patient on time. 3. Ask the medical student who cannot upload the form in time. Finally, the judgment says time is precious. Time and tide waits for none. This all of us know. The issue in this case is interpretation of section 144C(13), which prescribes certain limitation for passing assessment orders. Whether the time limit provided under that section is mandatory or directory. That is the issue before this court. The simple facts are dates are important. Assessment year is 2010-11, 6/9/2012. Reference was made to TPO under section 92CA of the Income Tax Act. 28/1/2014, TPO proposed adjustment of rupees 108 crores. 28/3/2014, draft assessment order was passed and objections to the draft assessment order was filed by the assessee. 19/12/2014, DRP gave direction to the transfer pricing officer or assessing officer. 23/12/2014, DRP directions were received by the AO. 5/1/2015, AO forwarded it to transfer pricing officer. 27/1/2015, TPO, that is transfer pricing officer, made adjustment as per directions of DRP, dispute resolution panel. Then 27/2/2015, AO passed the assessment order. That is, DRP directions only 2 days, which is very important, which are very important for this case, which I am quoting again. 23/12/2014, DRP directions were received by the AO. Then 27/2/2015, AO passed the assessment order. These 2 dates are very, very important. Then the assessee filed an appeal to the tribunal. The tribunal allowed the appeal on the ground. Order is framed beyond the period of 1 month from the end of the month in which the DRP's directions were received by AO, and hence the order is time barred. Against this order, appeal filed against this by the assessee before the Bombay High Court. Now, Bombay High Court looked into the objective and scheme of the Act. Objective of section 144C. The main objective of this section, which was introduced to, was to introduce to address the concern of MNCs, to provide a mechanism for speedy disposal of the cases. That is the objective of section 144C. The court analyzed the scheme of section 144C, and as per section 144C(13), that is the main section under which the order is passed, the court said, upon receipt of directions issued, the section says, upon receipt of directions issued by DRP, the AO shall, that is very, very important. The word shall is very important here. In conformity with the directions, complete the assessment without providing any further opportunity of hearing to the assessee. Within 1 month, these are the important words, within 1 month from the end of the month in which the directions were received by AO. So AO has to pass the order within 1 month from the end of the month in which the directions were received by AO. This is notwithstanding anything contained in section 153 that prescribes a specific time limit. Now, coming to the facts of the case, 23/12/2014 DRP directions were received by AO. So, the order should have been passed before 31/1/2015 because the section says within 1 month from the end of the month in which the directions were received. So, it was received in December. End of the month is December 31st, it is over. So, he should have ideally passed the order before the end of January. Now, he passed the order only on 27/2/2015. Section 144C(13) overrides the time limit given under section 153. The High Court said, that is, on receipt of directions from DRP, by adding 1 month from the end of the month in which such directions are received, AO has to pass an order. The court rejected the submission that the time limit is only directory. It held that the exercise carried out by DRP is for guidance of AO for completing the assessment in accordance with the directions of DRP, and hence it cannot be said to be ministerial act. The court said if the contention of revenue that the time limit is only directory is accepted, then there will be an uncertainty within which the AO has to complete the assessment. It will be contrary to the object and mandate of section 144C(13). The court was of the opinion that providing time limit is an inbuilt safeguard to prevent possible abuse or misuse of power by the AO. Section 144C(13) uses the word shall. So, court said it is a settled position, and more particularly in fiscal statutes, if an authority is required to complete the assessment within a certain time frame, then the same must be done within that time. If any order is passed beyond that time limit, then it is barred by limitation. The mandate to complete the assessment in time is absolute, explicit, and preemptory. The power to make assessment lapses completely upon the expiry of the period. That is what the court says. The court appreciated that fixation of period of limitation to some extent, it may be arbitrary and may result in hardship also. But in fiscal statutes, equitable considerations are out of place, and strict grammatical meaning of the words is only the safeguard. That is what the court says. While applying limitation, court cannot take into account such extraneous considerations. Then the next submission, the submission that the time limit should be counted from the end of the month in which the TPO's order was received by AO, that was also negatived by the court. The court held that the order must be passed within 1 month from the end of the month in which the directions were received from the DRP. The court held that the order passed by AO is barred by limitation, and on that ground it upheld the order of the tribunal. Finally, my comments are, so if you ask a runner who missed his time by a few seconds, then he will know how precious the time is. On the contrary, if you ask an advocate who patiently waits for his hearing throughout the day in the court, and sometimes it may not reach also, or the advocate, because his case is there, so he may be there in the court or in the bar association room or in the canteen, how much time he wastes in his life, that only he can say. Some advocates may waste their entire life. So, time is precious for some. For some, it is a luxury. That is what I want to say. Thank you very much. Have a great day.